relates to academic biomedical research. What I'll talk about to begin with is the GDPR in general, and then drill down into the research exemptions, which are the general research exemptions, and finally into the exemptions for public interest processing, which I think in an academic context may be as relevant as the research exemptions, but I'll come to that in a moment. So if I could have the second slide, I thought it would be helpful to begin by just placing this in a broader chronological context, because obviously the GDPR is not coming in to a vacuum when it comes to European data protection. In fact, we've had 50 years of European data protection starting in the 1970s. We've had a binding legal instrument since the 1980s, the Council of Europe Convention of 1981. I suppose a very big development came when the EU got formally involved and enacted a directive giving substance and additional specifications to the convention, and that's Directive 95/46, which you've probably all become rather familiar with. Fast forward to the 2010s, that's now being transformed and further harmonised through the regulation coming into force next May. But the only other thing to emphasise is since the 2000s, the other big development has been the recognition of data protection as a fundamental right in itself. This began in 2000 with the drafting of the European Union Charter of Rights, but the legal force of that instrument wasn't given effect to until 2009. And I think since then, we've seen it influence interpretation of statutory data protection law, particularly from the EU's top court, the Court of Justice, quite significantly. So if we could go to the next slide, then I suppose where we could begin is talk about the scope of the GDPR, and by default that scope is very, very broad. So I think it's very likely that much of biomedical research and much of the Human Brain Project, at least obviously the human side of it rather than the animal side of it, will likely to some extent fall within its scope. So its fundamental concepts are processing and personal data or personal information. Now, personal data is anything which relates to an identified or identifiable individual. That information doesn't need to be particularly intimate. In fact, it could be rather trivial. It doesn't need to be private. It could be fully in the public domain, available by a Google search. Probably of more relevance to the project in terms of the breadth, though, relates to the meaning of identified or identifiable. It's not necessary that you identify in terms of knowing the name, the address, how to track down an individual. Potentially just sort of distinguishing them, pinpointing them, and being able to target them in a way is enough. And the data itself doesn't need to enable you to do that. That data in combination with other data is going to make the data identifiable. As long as, in the words of the regulation, it's reasonably likely that that combination could take place. Now, because the whole purpose of the European data protection is to protect individual rights, that kind of concept of reasonably likely has been interpreted very, very broadly. So in Brea, which is the case I put at the bottom of that slide, the court was asked about, the Court of Justice of the EU, was asked about dynamic IP addresses. These are Internet Protocol addresses which change all the time. But the ISP, the Internet Service Provider, can technically re-identify those individuals if they're specifically requested and there's a legal obligation of them to do so. But even in the hands of other people, the court said that that must be treated as personal data because it was not practically impossible, in their words, that re-identification could take place. And I mean, that raises some interesting issues in the research context around things like DNA data or highly pseudonymized data, which, yes, technically could be recombined or combined with other data to identify someone. I don't think that there's been case law quite in that area. Some case law, like on the dynamic IP addresses, would tend to suggest that data remains personal data. Now, what way do you need to handle personal data to be covered by the law? Well, you need to carry out processing on a digital device, or also, or maybe even in a structured manual file. But with ubiquitous computing, computers, digital devices, we're all using them all the time. And processing means anything performed on that data. Even looking at the data, bringing it up on screen is an operation of processing. Even deleting the data is a processing. Now that leads some to argue that the process of anonymization itself, which can, if it is taken far enough, take data out of these definitions, is itself a processing operation on them, which at least it could trigger various rights of transparency over that operation for the individual data subject whose data, in a way, it is. Again, you know, some would disagree with that, but it's difficult to see why a deletion of data itself isn't processing, how anonymization techniques can't also be processing. I won't go into the territorial scope, which is at the bottom of the slide, because I think time is quite short. I'll move on to talk about, well, what are the default duties then which come from processing this personal information? So the next slide talks about these duties, and rather like the scope of the GDPR to protect rights is very broad, protect privacy and related rights, the duties are quite broad, again, to kind of cover the field of the ways in which individuals can be impacted by the processing of data relating to them. So if we start on the right-hand corner of that diagram, we can see that the starting point of these sort of broad data principles of fairness, lawfulness, transparency, knowing what purposes you're processing the data for, and limiting the further processing, ensuring the quality of the information, its accuracy, its relevance, and these sorts of things, quite broad and open textured. But combined to that, they are two sets of much more detailed rules attached to processing data. The first set of rules really apply to any processing of data because they relate to transparency and then a degree of subjective control by the data subject, the individual to whom the data relates, over that processing. So if we look at the second kind of square, one to the left now, transparency obligations have a proactive element. These are sort of the privacy notices which need to be given to data subjects pretty much in all circumstances when data is directly collected from them, and subject to some limitations, but also when data may be indirectly sourced from a third party or the public domain. And then there's a retroactive or subject-led further access right, which is on demand. The individual has a right to access data, pretty much all of the data in that case, because obviously a privacy notice can't contain all of the data. It can only give a rough indication of what's going on. And then the individual has rights to demand the erasure of illegal processed data, that's sort of the so-called right to be forgotten, but also to object on their own individual grounds, which the controller of the processing may not be aware of, which they need to take into account then to see if the processing remains legitimate. Moving on further to the left, and again, there's sort of quite a lot of centrality for biomedical research in this project, certain categories of data are regulated much more strictly, and that's so-called sensitive categories of data, and includes data concerning health, which the court in a case as far back as 2003, the Lindquist case, again on the previous slide, says needs a wide interpretation to protect a right. Now, the general situation here is that unless the data subject has waived their right to have that data not processed, either by giving their explicit consent or if they're manifestly putting that data into the public domain, so they've got a blog talking about having a certain disease, then that data should not be processed. That's the default rule. Finally, we get to sort of a whole load of discipline rules which are designed to, in principle, ensure that the controller really is controlling the data through data security policies, record-keeping policies, ensuring that the data isn't exported outside the EU in a jurisdiction which it then would lack these kind of protections. And that's meant to be overseen by data protection authorities, by regulators, as well as by the court. So clearly, particularly the sensitive data ban, but also potentially some of the other provisions, especially around transparency, could pose quite a threat to forms of research based on large amounts of data in the public interest. And where most researchers look to in terms of establishing a better balance is to the specific research-only exemptions which are now found in Article 89 of the regulation. So just turning to the next slide then, what I've tried to do here is colour code in a sort of traffic light way what that research-only article gets you in terms of limits to these wide default duties. So the stuff in green is stuff which the regulation itself sets down limits or exemptions to. And as we move to amber and yellow, it's more optional on the member states whether to provide that. And finally, we get to red, where using this clause, even member states optionally can't provide a derogation. And we can see that, there are some significant exemptions. So you can process data for a different purpose than which it was originally collected. It will not be considered incompatible with the purpose limitation. And you can then obviously store it longer than you otherwise would for the old purpose. Similarly, there can be exemptions or limitations on subject access, certain control rights, and on sensitive data. But whereas the regulation initially in many drafts is going to introduce a mandatory exemption for the consent rule in processing sensitive data for research, that got watered down at the last stages to essentially say that it was up to member states to provide a law providing this which was proportionate and reasonable and had safeguards in it. And so some countries like the UK will certainly, and in fact the Data Protection Bill is now being published, will certainly make full use of all of these exemptions and derogations, but many other countries will not. And I suspect we'll see quite a mosaic of different laws, particularly around sensitive data and research. But what I think is also quite striking in that diagram is how much remains in red. So all of the proactive transparency provisions remain in red in this diagram, and therefore can't be derogated from even by member states which want to make a derogation for scientific research or historical research, at least using this clause. And that brings me to kind of what is this clause trying to do, because this clause actually protects even the commercial-driven, purely private interest processing for research purposes of Google and Facebook and LinkedIn and all the other online operatives. It's not targeted towards public interest processing, which is in furtherance of academic freedom, a fundamental right to the EU Charter, and sort of in the high public interest of helping well-being and saving lives. that form of processing actually might benefit from further exemptions. So why might that matter? Well, it might matter in relation to records-based research, because if you have a whole load of records and you're thinking of imparting it to a researcher in a way that can't be fully anonymized, or potentially even if the anonymization process itself is a processing operation and you need to get the data ready for giving to a researcher, you will be processing for a new purpose, a purpose which isn't the original purpose of, say, providing care to that specific individual. And as you're kind of directly, the information has originally come directly from the data subject to you, you will be tied, in theory, to the very strict requirement to supply processing information in a data privacy notice, including any subsequent repurposing of the data, even if that data repurposing is compatible, which it will be because of the limit on purpose limitation. But it may be very disproportionate to let every individual know, and it may even be impossible, because that information may remain identifiable in the very broad sense that I've talked about, but it doesn't mean that you can, in a verifiable way, know the name, the address, the email contact, or physical address of individuals to write to. And we can, to take the thing a bit further, to try and do so could even be a data security problem, because if you start trying to track people down and the data actually isn't accurate and it's not up to date and people have moved or you're not even sure you're getting the right person, you could be disclosing sensitive personal data very quickly in a way which could breach other requirements. So I'm going to skip the next 1, 2, 3, 4 slides, if possible, and take you to a slide which looks at public interest exemptions within the regulation, which are in Article 23, and this is the slide headed GDPR General Restrictions. And Article 23 allows further exemptions at member state level for important objectives of general public interest, or, as I say, in furtherance of a right or freedom, such as freedom of the sciences or academic freedom found in the EU Charter. And as we can see from that diagram, all of the transparency and control provisions are now in green. And so using this public interest clause, member states are able to provide the necessary exemptions for records-based research under this clause. If we go to the next slide, which looks at the conditions, then we can see that, yes, in some way that the laws which provide that derogation need to be quite specific as to the purposes, the categories of data, the scope of these restrictions. That should be perfectly possible in a research context. It seems unlikely, at least initially, that many member states will actually make use of these derogations to provide research leeways. The Netherlands do appear to be doing this by allowing controllers to self-certify that an exemption or derogation from, say, the transparency rules is necessary, and themselves monitoring that and themselves creating a template of the scope of the restrictions and the safeguards. The UK bill, which was literally published about a week ago, doesn't provide any research derogations beyond the Article 89 derogation or the sensitive personal data derogation. But it does have a clause which enables the government at a later date to establish any derogations it sees fit. And rather like in the directive era, what we may see is legal uncertainties, legal problems occurring, and a number of years later, legal solutions being crafted. It's not ideal, but that's probably the reality we're still heading towards. So just to move to the final slide, just some conclusions. I mean, it's clear that scientific research, all scientific research, even if it's conducted by Google for purely commercial purposes, has a privileged position within European data protection. But compared to the directive, what we need to bear in mind is that the GDPR is much more onerous, and the default provisions are much stricter. And we can see that maybe most clearly around the transparency rule provision. And I think that's where the whole idea of using more of the general public interest derogations come in. And I think in an academic context, we need to think clearly as to whether we need those derogations, and if we need them, make that clear to our government. Because as I say, this very much is an area where there's going to be a lot of different member states doing a lot of different things into the future. So thank you for bearing with me, and I'm happy to answer any specific questions.